first group, we can give them about an hour, and the other one another hour. Well, actually, let's do 30 minutes and see. Then we'll have Q&A. So let's start with the first group, the ones who are dealing with the Nuremberg Tribunal. Sorry.
Yes, Mwalimu, thank you. That will be group 1.
Yes.
Where I belong.
Good. The guy, the floor is yours and your team.
Thank you. Would you kindly allow me to share the PowerPoint?
Oh yeah, definitely, yes. Definitely. Just give me a minute. Okay, there you go. You can share.
Okay, thank you, Mwalimu. Kindly, can I get confirmation that you can see my slides?
Yeah, I can see your slides.
Okay, thank you, Mwalimu and colleagues. So my name is Zedekiah Odhiambo. I belong to group 1. And the following on your screen are also members of group 1. So we have structured our presentation this way. I hope we manage it within the 30 minutes. So under creation of the tribunal, that will be undertaken by J.N. Kariuki. Then myself and Thomas will tackle the rationale for the tribunal. Jurisdiction and powers will be done by Lauren. Successes and failures will be undertaken by Merab Queen. And lastly, major contributions shall be done by Njoki Bashanja. So thank you and welcome to our group presentation. So let me invite J.N. Kariuki to proceed from there. Thank you.
Okay, thanks, Zedekiah. But just before you begin, let me just inform the rest of the class. If you have any question, you can post it on the chat, or just note it down. Then we'll ask after everybody's done. Thanks. Okay, move on.
Thank you for that, Mwalimu. So, Kariuki, the floor is yours.
Thank you, Mwalimu, and thank you, Zedekiah. Good evening. My name is Kariuki. So I'll go. So International Military Tribunal, that is IMT Nuremberg, it was established in 1945, but before that, December 1942, the allied leaders of Great Britain, the United States, and the Soviet issued the first joint declaration officially noting the mass murder of European Jews and resolving to prosecute those responsible for violence against civilian populations. So we are saying that in 1942, that is when at least the leaders of the leading countries in the Allies, they felt, they officially recognized it could not be ignored any longer, that indeed there was a problem, the Jews were being exterminated and something needed to be done. But it was not until 1945 that the laws and procedures for the tribunal were established. And Nuremberg was chosen. I think that is a place where Hitler and his men used to meet to spread their propaganda against the Jews and do their rallies, especially to spread the hate against Jews. So it was also a symbolic choice for the venue to do the trials. So we proceed. Okay, so the charter defined 3 categories of crimes. And those categories were crimes against peace, that is including planning, preparing, starting or waging wars of aggression or wars in violation of international agreements. Even up to that time, there were agreements about war, even from the World War I. And so that it was, okay, the committee or the people who came together to form the judiciary, the one that was going to try the cases, they had to establish that in the charter, and that is crimes against peace. So the next one is war crimes, violation of customs or laws of war, including improper treatment of civilians and prisoners of war. The next one was crimes against humanity, and that included murder, enslavement or deportation of civilians, or persecution on political, religious, or racial grounds. So we are saying with the establishment of Nuremberg, there needed to be the basis for the charges that would be made. And that's why those crimes had to be clarified before the trials began. So on November 20, 1945 to October 1, 1946, that is when we have the trial of major war criminals, the people who were identified to have the greatest responsibility for the war. And we can note some of the leaders. They committed suicide just before the trials began. That includes Hitler and Joseph Goebbels, who was the minister for propaganda. So those ones evaded the trial through suicide, but others were tried. So first of all, there were prosecutors and defense attorneys, according to British and American law, but the decisions and sentences were imposed by a tribunal, a panel of judges. Unlike maybe in America, there is a judge and a jury. So that part was not applied, but the law, there were prosecutors and defense attorneys according to the laws of America and Britain. So each of the four allied powers, that is US, United Kingdom, France, and Soviet Union, provided two judges. There was a main judge and an alternate judge. So from there, after those trials, we have the subsequent trials from December 1946 to April 1949. So in that period, 12 additional trials were held at Nuremberg. So we say these were conducted before US military tribunals rather than the international tribunal that decided the fate of the major Nazi leaders. When the major tribunal was going on with the trial of the main judge, the main criminals, I think some disagreements, although those cases were concluded, some were forgiven and others were found guilty. Sorry, some were found not guilty and others guilty, and the sentences issued. There had been issues among the four allied powers about the conduct of those cases. So in the subsequent trials, only US participated. So I think I have said more than I need to do. The next person will elaborate further. Thank you.
Thank you, Kariuki. The next step is the rationale for the creation of the tribunal. And this is my part and Thomas. I don't know whether, Thomas, you are ready. You can start, then I finalize, or I can start, then you finalize.
Let me start right away.
Okay, thank you.
Given the proper introduction that our colleague has given us on the background that led to the creation of the International Military Tribunal, at the end stage of 1945 for a war that had been fought since 1939, there was this international cry that over less than a generation, over less than a human generation, the world had encountered and seen unforeseen suffering of humankind, and also 2 world wars, which were unprecedented. At that point in 1946, when at that point around the end of the Second World War, when the International Military Tribunal was formed, there was a general agreement among the nations of the world involved, the influential ones, that never again should the world find itself in a position of having a third world war or having any of the factors that had necessitated such suffering happening again. Therefore, with the creation of the International Military Tribunal, the following were some of the rationales that grounded the decision to create the tribunal. Number one, accountability for war crimes. There was need to be able to prosecute these war crimes and hold accountable those who had been involved. This is in line with the cry that nations of the world shared, that never again shall we in our lifetimes and future generations ever have a world war or 2 world wars or any that we have seen. And I think this is also reflected in the preamble of the United Nations Charter, which came into force around that time, that nations of the world are coming together in the spirit of participation, resolving disputes, so that we will never have any possibility again of factors that would create a dispute large enough to necessitate such suffering that had been seen. So the first one was creating accountability, because there can be no peace without justice. People had suffered. The Jews had lost a lot of their lives. Germany was on a rampage trying to take over the whole of Europe. There was a lot of suffering in the UK and so on and so forth. And so many battles, the Battle of the Somme in France, which we remember as part of the Second World War, which was one of the main battles that really killed a lot of people. Apart from the accountability for war crimes, there was also a need to set precedent. Set precedents for any atrocities or any kind of such situations that would happen in future in regard to holding these people accountable and being able to deliver justice. Number three, the whole thing about criminal law, generally both international criminal law and municipal criminal law as it applies in Kenya, probably in other countries, there's always a moral element to it. And I remember there was some time we were having a discussion with one of the trainers who had come to the University of Nairobi, Mombasa campus, and he told us during closing statements by counsels, this is where we pose a moral statement to the judge and ask them that we want you, for example, the defense counsel would ask the judge, we want you to impose the maximum penalty so as to pass a message to any potential perpetrator out there about this offense. Therefore, based on this same principle, the tribunal was there to act as a deterrent to any other person who would even perpetrate in the farthest thought, taking over or undertaking such an action. Also, the tribunal was premised under the rationale of delivering justice and also confronting what had happened. Nazi Germany had run havoc all over. Poland, there was a time actually Poland surrendered. France, one of the big countries, had also surrendered. So many other things had happened because it was until I think the last month of the war that Hitler decided he was losing. Otherwise, basically, he was running the show all over. And that's it. So justice and also reckoning of the situation, being able to confront it one-on-one. What happened? What led to us to get where we are? Even though this was not delivered, because we saw after that, the Cold War immediately started after the Second World War, featuring two countries that had been both members of the Allied powers, the United States and the Soviet Union. We also needed to hold the specific individuals who had ensured that this atrocity happened, to hold them accountable. Hitler had died, other people had died. But we also had people like Adolf Eichmann, who was in charge of the death camps whereby these Jews were killed, Adolf Eichmann. We also have Herbert Kuka, who was caught by the Mossad in Argentina, Herbert Kuka. All these were people that had to be held individually so as to communicate a message to other perpetrators. Also, there was need to create a framework, a legal framework through which various countries of the world can come together and ensure a uniform, unified, single approach towards dealing with this issue of accountability and justice. And this tribunal, therefore, ensured that platform that countries could come together and hold the perpetrators accountable. And finally, because countries would come together and justice and accountability steps would be taken towards it, such would ensure the promotion of peace and international stability. And with that, I come to the end and hand it over to Zedekiah to explain a bit better and more comprehensively on the rationale for the creation of the International Military Tribunal.
Thank you, my brother Thomas, for that wonderful and eloquent presentation. Now, maybe to add a few, because I see that you have tackled all the rationale. Now, I'm assuming we all know or understand how the World War I broke out. And while doing my research, some authors said that that one of the main rationale for the creation of the tribunal was because if you look at the whole time that the World War I was happening, there were also serious atrocities that were committed against the innocent, women and children. And so towards the end of it, there was that, though in the minority, there was that call that maybe those who instigated the war should, should be punished in one way or another. But this minority call for punishment of the instigators of the World War I did not gather much pace, and in fact, it was not really supported by majority of the countries. So you find that those who created or those who made it possible for the World War I to happen, whereby many people died, they were never punished for that. And so when the tribunal was created, that is in the London Conference, I think it's early 1945, the allies, that is the US, the UK, France, and the Soviet Union, said that never again shall we allow a person, a country, or a group of countries to just one day wake up and start killing people everywhere, or occupying other people's countries without any justification. So that one was also one of the rationale for the creation of the tribunal, that after what happened in World War I, nothing happened, because those who instigated that conflict were never punished. And then number two, the Ukrainian genocide, though, was it Turkey or which country? Though they deny that it was not a genocide, but it is recorded in history that it is a genocide. Also, when you look at how that the aftermath of the genocide was treated, no one actually was held accountable for that. There was no individual responsibility for those who instigated the Ukrainian genocide. So this one, I can also say, was also one of the rationale for the creation of the tribunal, so that never again shall the world sit and watch while a genocide is happening in another country. So in addition to what Thomas has said, Mwalimu, I will end my presentation there for the rationale for the creation of the tribunal, and invite Lorraine to tackle jurisdiction and the powers of the tribunal. Thank you. Lorraine?
Thank you, Zedekiah. Good evening. I'll be taking you through the jurisdiction and powers of the tribunal. The jurisdiction of the International Military Tribunal was defined in Articles 6 to 12 of the Nuremberg Charter, which was the legal basis for the tribunal's operations. And we see that the principal jurisdiction was to prosecute persons for crime against peace, war crimes, and crimes against humanity, and conspiracy to commit these crimes. And the tribunal's power extended to trying individuals for their personal culpability in organizing and carrying out those atrocities rather than the entire organizations. Also, under Article 6 of the Charter, it delineated 3 types of offenses falling under the jurisdictions of the International Military Tribunal. We've said they were crimes against peace, war crimes, and crimes against humanity. These war crimes, they have been spoken by sorry for that. Within the jurisdictions, those holding high-ranking positions in the government did not exempt individuals from being held accountable or reduce the severity of the punishment. In simpler terms, being a head of a state or a government official did not provide immunity from legal prosecution. And also regarding the matter of the defense of acting pursuant to orders, those obeying orders from the government or a superior did not absolve a defendant from accountability, although it was taken into account as a mitigating factor if the tribunal deemed it fair. The tribunal also had the authority to make such a declaration in relation to the conviction of a member. Members of the organization were also entitled to express their opinions regarding the organization's criminal nature. The jurisdiction also granted individuals convicted by the tribunal the opportunity to face additional charges in national, military, or occupation courts for offenses other than belonging to a criminal group. These courts had the authority to impose punishment separately and in addition to the punishment imposed by the tribunal. The tribunal also retained the authority to take action against an individual accused of crimes in their absence if they had not been located or if it's deemed essential by the tribunal. When we go to powers are under Article 17 of the Nuremberg Charter. They're outlined under Article 17, and the tribunal was granted the authority to establish its own rules of procedure. It was also granted the authority to consider any evidence it considered pertinent to the case, regardless of its admissibility according to national law. The tribunal also had the power to designate officers essential for the smooth operation of the court, which encompasses the appointment of a prosecutor. Yeah. That's the end of my presentation. I think I'll welcome the next person.
Thank you. Thank you, Lorraine. We have got Merab Queen will talk to us about successes and failures of the tribunal. Merab, the floor is yours. Thank you.
Thank you. Good evening. I'll be taking us through the successes and failures of the tribunal, starting with the successes. The first one was establishment of international crimes as separate offenses. These international crimes were two of them. So the first one was recognition of crimes against humanity as a distinct offense, which prior to the Nuremberg trials, crimes against humanity were not explicitly defined under international law. So the trials played a pivotal role in recognizing crimes against humanity as a distinct offense, encompassing widespread or systematic attacks against the civilian population, such as murder, extermination, enslavement. So this definition provided clarity and specificity to the concept of crimes against humanity, ensuring that such atrocities will not go unpunished. It also recognized crimes against peace as a distinct offense. The Nuremberg trials introduced the concept of crimes against peace, defining them as planning, preparation, initiation, or waging of war, of aggression, or a war in violation of international treaties, agreements, or assurances. So this recognition established that individuals could be held accountable for initiating unjust wars, regardless of their conduct during the conflict itself. The second one is recognition of command responsibility, which I think is what we learned in torts as vicarious liability. So the Nuremberg trials introduced and developed the principle of command responsibility, holding individuals in positions of authority accountable for the actions of their subordinates. So this principle established that individuals who knowingly ordered or failed to prevent subordinates from committing crimes against humanity or war crimes could be held criminally liable for those offenses. The third one is establishment of international legal. The third one is affirmation of universal jurisdiction. So during the Nuremberg trials, it affirmed the principle of universal jurisdiction, which allows any state to prosecute individuals for crimes against humanity and war crimes, regardless of where the crimes were committed or the nationality of the perpetrators. This principle enabled the pursuit for justice for individuals who suffered from these atrocities, regardless of their location. The next one is strengthening of international humanitarian law. So the trials played a pivotal role in strengthening IHL, which regulates the conduct of war and protects civilians during armed conflicts. The trials emphasized on the protection of civilians and the prohibition of certain acts of violence, contribution to the development of more rules of engagement and prevention of atrocities. The next success of the tribunal is establishment of international criminal tribunals. So the Nuremberg trials paved way for the establishment of international criminal tribunals such as ICC, ICTY, which have the mandate to prosecute individuals for the most serious crimes of international concern. Yeah, that's the most I can say about that. And the next one is the next success is promotion of international criminal justice, where trials, precedents, principles, and definition have been incorporated into the statutes of various international tribunals and the Rome Statute of the ICC. So the trials legacy is evident in the development of international criminal law, the establishment of international criminal tribunals, and the pursuit of accountability for atrocities committed worldwide. The next one is contribution to the rule of law. So despite shortcomings of the tribunal, it also played a significant role in strengthening the rule of law by establishing the principle that no one is above the law, regardless of their position or power. This principle serves as a cornerstone of international justice, as it underscores the importance of holding individuals accountable for their actions. And the last one is promotion and establishment of the transcription, translation, and interpretation services, whereby the Nuremberg trials marked the first large-scale international event to employ simultaneous interpretation on a widespread basis. So prior to this, the translation was typically conducted in a consecutive manner, where the interpreter would listen to a speaker, translate their remarks, and then relay the translation to the audience. So this process was time-consuming, inefficient, and especially during in multilingual settings. So to address this challenge, the Nuremberg trials organizers developed a system of simultaneous interpretation. So this involved using soundproof booths where the interpreters would listen to the speakers and relay their translation simultaneously through headsets. This system allowed for seamless communication among the multilingual participants, enabling the trials to proceed efficiently and effectively. So that's about the successes of the trial, of the Nuremberg Tribunal, and the failures. We firstly have retroactive application of the law. I think this is the most significant criticism of the Nuremberg Tribunal, because it applied ex post facto law, meaning that the defendants were charged with crimes that were not defined as crimes at the time they were committed. This raised concerns about fairness and the rule of law. So the principle of ex facto law basically prohibits the application of new criminal laws to actions that were not considered crimes at the time they were being committed. So this principle is based on the idea that individuals should have a clear notice of what is prohibited by law so that they can avoid violating it. So in the case of the Nuremberg trials, the defendants were charged with crimes against humanity and crimes against peace, which were not defined in international law until after the war. So the defendants couldn't have known that their actions were illegal, basically. So the retroactive application of law was a major concern, and it's considered the biggest failure of the Nuremberg trials. But despite these concerns, the Allies justified the retroactive application of law on the grounds that the Nazi crimes were so shocking, they were so bad that they couldn't be tolerated. So they argued that the Nuremberg trials were not a legal proceeding in the traditional sense, but rather a moral reckoning with the Nazi regime. So the specific criticisms of the retroactive application of law in the Nuremberg trials were three. Firstly, it violated the principle of nulla poena sine lege. I'll type it in the chat, but it basically means that no one can be punished for an act that was not a crime at the time it was committed. Secondly, it created uncertainty and instability in law, as individuals could never be sure which actions were legal or illegal. And thirdly, it undermined the rule of law, as it allowed governments to punish individuals for actions that were not prohibited by law. So that's about a retroactive application of the law. The second one was lack of due process. These trials were criticized for lacking due process, particularly for the defendants who were represented by legal counsel who were not given adequate time to prepare the defense. Due process is, as we learned, is a concept that protects individuals from unfair government actions, which includes right to fair trial, legal counsel, right to presumed innocent until proven guilty. So the trials were conducted in a hurry, and the defendants were not given adequate time to prepare their defense. So this was due in part to the fact that the allies were eager to bring the trials to a conclusion to punish the perpetrators of the Nazi crimes. So as a result, the lack of due process, some of the defendants were not able to present their full defense, and this led to concerns that the trials were not fair and that the defendants were not given a chance to prove their innocence. Third, failure of the Nuremberg trials is limited scope. So the trials focused on the major Nazi leaders and did not address the broader issue of complicity in Nazi crimes. This allowed many individuals who had participated in Nazi crimes to escape justice. The Nuremberg trials were limited in scope because the Allies were focused on prosecuting the most senior Nazi leaders and did not have the resources or time to prosecute all the individuals who had participated in the Nazi crimes. So as a result of the limited scope of the trials, many individuals who had participated in those crimes were not brought to justice. This included individuals who had committed atrocities on the front lines, as well as individuals who had worked in the concentration camps. Political motivations is the fourth failure. So the Nuremberg trials were not without political motivations, as the Allied powers sought to punish the enemies and establish their own dominance in the post-war world. This led to some criticisms that the trials were not impartial. So the Allied powers were the victors of World War II, and they had a strong interest in punishing the perpetrators of the Nazi crimes. So they wanted to establish their own dominance in the post-war world, and the Nuremberg trials were seen as a way to do so. So as a result, the political motivations of the trials, some of the defendants were treated unfairly. For example, some of the defendants were not allowed to present their full defense, and some of the judges were biased against the defendants. Lastly, there was limited impact on future atrocities. So while the trials set important precedents in international law, they did not prevent future atrocities from occurring. The world has continued to witness war crimes and crimes against humanity. Even as we speak, they're still ongoing in Congo, in Palestine, and the Nuremberg trials. So the Nuremberg trials were not a way to solve the problem of war crimes and crimes against humanity. They were a first step in development of international criminal law, but they did not eliminate the root causes of these crimes. So as a result, we've continued to witness these crimes in countries like Rwanda, Congo, Bosnia, Sudan. And despite the limited impact of the Nuremberg trials on future atrocities, they were an important step in the development of international criminal law. That is it on the successes and failures. Unless anyone wants to add on something, I'd like to move on to the last bit of our presentation.
Yes, proceed. Merab.
Okay, so
We'll make our final submissions later.
okay. I'll also present on the major contributions of the Nuremberg military tribunal. And the first one, most of these contributions of the tribunal to ICL relate to the successes that I've just discussed. But the first one is the establishment of individual responsibility. So the Nuremberg trials marked a moment in international law by firmly establishing the principle that individuals can be held criminally accountable for war crimes and crimes against humanity, regardless of their position or authority. So this principle overturned the traditional notions that we had of state sovereignty, which often shielded individuals in position of power from legal consequences. So the trial's emphasis on individual accountability underscored the moral and legal obligation of individuals to disobey orders that violate fundamental human rights. This principle has become a cornerstone in international criminal law, enshrined in various statutes of international law, international tribunals, and the Rome Statute of the ICC. Secondly was the definition of war crimes. So the Nuremberg Charter, which established the framework for the trial, defined war crimes as violations of the laws or customs of war. So this included acts such as murder, ill treatment, and deportation of protected persons. Yeah, such acts. So these definitions provided a clear legal basis for prosecuting individuals for war crimes, and they have been incorporated into subsequent international treaties and conventions. Thirdly, crimes against humanity. The Nuremberg trials also established the concept of crimes against humanity, which encompass acts of widespread or systematic violence against a civilian population. The Nuremberg Charter defined crimes against humanity as murder, extermination, enslavement, deportation, and other inhumane acts done against any civilian population or persecutions on political, radical, or religious grounds. So this definition recognized the inherent wrongfulness of these crimes, regardless of whether they were committed during wartime or not. The fourth one is prosecution of crime of aggression. So the Nuremberg trials broke new ground by prosecuting individuals for aggressive war, also known as war of aggression. This concept was not recognized under international law at the time, but the trials argued that aggressive war was a crime against international peace and security, punishable, and that paved way for future prosecutions of leaders responsible for launching illegal wars. The fourth one is principle of fair trial, and the Nuremberg trials adhered to the principle of one is precedent for future tribunals. The Nuremberg trials established a precedent for future international criminal tribunals such as ICTY and the ICC. So these tribunals have drawn on the Nuremberg trials jurisprudence and procedures in their own proceedings. The seventh one is codification of principles. The Nuremberg trials contributed to the codification of principles of international criminal law, which have been embodied in subsequent treaties and conventions. These principles form the basis of prosecutions of individuals for crimes under international law. The eighth is recognition of superior responsibility, where the trials recognized this concept, which holds that superiors are liable for the crimes committed by their subordinates if they knew or should have known about the crimes and failed to take appropriate action to prevent or punish them. This, again, is what is referred to as vicarious liability in torts. Yeah. So this principle has been instrumental in holding commanders accountable for atrocities committed by their troops. And lastly, we have humanitarian values, where the trials affirm the importance of humanitarian values and the need to hold individuals accountable for their actions, even when they are committed in the name of a state or a political ideology. The trials sent a powerful message that the crimes against humanity will not be tolerated, and those principles will be, those responsible, will be brought to justice. So that is it for my presentation. Opening the floor to questions or anyone who has a comment to make in my group. Thank you.
Thank you, Merab, for that wonderful presentation. Mwalimu, if you indulge me for a minute or so, in conclusion, I have got two issues. Number one, there's a gentleman known as Christian Tomuscat. Is it Tomuscat or Tomuschat? Now, I think he's a law scholar, and in his article where he discusses the whole Nuremberg trials, he says that, and here he cites another German scholar by the name Christoph Burchard, and he says that there were two failures that were, expressed by the German population during and after the trials, and these ones were very specific to the German population. Number one, Christoph Burchard says that the German population were of the opinion that the Nuremberg trials lacked impartiality of the judges, because if you look at the way the trials were, structured through the charter, the Nuremberg Charter, you'll find that the judges were handpicked by the Allies, and these handpicked judges were from the countries of the Allies. So, for example, the US contributed 2 judges, France 2 judges, Soviet Union 2 judges, and the UK 2 judges. So the German population were of the opinion that if the international community wanted, an impartial tribunal, then they ought to have also selected judges from other neutral countries. So that is one of the failures that that was expressed by the German. And number two, the second failure that was expressed by the German was the fact that you find that the Germans argue that the trial was flawed by its fundamental discriminatory nature. Now, the Germans argued that the same atrocities, the same crimes that the Nazi Germany are being accused of, are being prosecuted for, are the same crimes that the Allies also committed. So they were of the opinion, the Germans were of the opinion that why is it that it is only these people that have been, you know, kind of ring-fenced for trial, and yet the crimes you are accusing them to have committed, you also committed it. And if you read most materials, that is one of the defense strategies that was deployed by the defense team. But then the judges overruled that, and that did not see the light of the day. But it is a valid, it was a valid concern. The second one and the last one, if you read most materials, most books on the Nuremberg trials, overall it was a success, because number one, apart from the main trial that was happening at the IMT, that is the International Military Tribunal, the US later on, as stated by my colleague Kariuki in his first presentation, constituted another trials. And the trials that were conducted by the US, they were charging or they were prosecuting now groups or organizations affiliated to the Nazi Germany. And to this end, the US prosecuted lawyers, they prosecuted doctors, they prosecuted some corporations and all that. So if you look at the whole Nuremberg tribunal and the trials as a whole, most materials or most books will tell you that it was a success, and I tend to agree. Because the interesting part is the lessons or the failures that were identified in the Nuremberg tribunal, they were modified and improved in the next tribunal that I think Group 2 will be telling us about. So that you find that, as my colleague Merhaba said, that in the Nuremberg tribunal, there was a huge problem with transcription, translation, and all that. If you look at the process of the Tokyo tribunal, you'll find that it was the challenges that were identified in the Nuremberg tribunal were kind of done away with. They were sorted out by the time the international community were constituting another tribunal in Tokyo, known as the Tokyo Tribunal. So, Mwalimu and the class, that is the end of our presentation. And as my colleague has said, we welcome any questions or comment. Thank you very much. Hello? Can someone hear me?
Yeah, we're getting you.
Okay. The floor is yours for questions or comment, and we'll try our best to respond to them. Thank you. Back to you, Mwalimu.
Can I comment?
Yes, please. Yes, please.
This is Onyoike. I know the Nuremberg is important to us both in the medical profession, because the medical atrocities that were conducted during that time resulted in some code of some, that guide us even today, up to today, on experiments on related to human beings or scientific experiments. So when we are looking at the benefits that came out, or the contributions to the world or to the international criminal law, right from the Nuremberg, is this code that guides experiments on scientific experiments that arose out of the Nuremberg tribunal. I don't know whether in my
Yes,
reading it came across that is a 10-point kind of a guiding principle on scientific experiments. But that is one of the important contributions to international criminal law.
Thank you, Wanyaike. I, speaking for myself, I did not come across such, but we thank you for that comment. And it's true that among the atrocities that, for example, the doctors were accused of was the experimentations that they were doing on the Jews. Thank you very much for that, for letting us know that the Nuremberg trial or the tribunal also had got a major impact on the medical profession. Thank you for that, my brother.
Zedekiah, I have a question.
Yes.
I've posted it in the comments, but I can also repeat it. So in one of the defendants was Martin Bormann, who was Hitler's private secretary, and he was indicted and tried and convicted in absentia. So this provision was anchored on Article 12 of the IMT, and I just wanted to find out from the research that you did, would you term this allowance as a success or failure? And how do you think it relates to the right to a fair trial? Yeah.
Yes, thank you. I'm assuming it's Wendo, if I'm correct. Wendo Gidaka. Is that right?
Yes.
Okay, thank you. Now, thank you for bringing this to our attention. Yes, it's true that in the charter, there was a provision for trying or prosecuting the war criminals, some war criminals, or any war criminal in absentia. Now, I will respond this way, and Mwalimu will also assist us. Now, at the time the trial was happening, I would say it was a success. Because remember, the objective of the Allies were that we are going to prosecute all and any person who was involved or who was associated with the Nazi Germany and also was involved in the suffering of our people. Remember, the Allies, the UK, the US, USSR, and France, each of those parties, and especially the UK and the USSR, they had got very, how should I say it, very crude ways of dealing with these criminals. So that you find that, for example, the UK were of the opinion that let us round up these people, the major ones, the main ones, and do what is called summary execution. While the USSR, that is the Soviet Union, were of the opinion that let us do a short trial. Basically, a short trial is basically it is kind of a flawed trial. It's a false trial where we are not interested in knowing your innocence or guilt of what you did, because we know you did it. So we are just doing it to show members of the public and others who would be interested in who will be thinking of doing such kind of atrocities to act as a deterrence. Otherwise, your guilt or your innocence is not their problem. So I would respond that at the time the tribunal was constituted, or at the time the trials were going on, I would say it was a success, because none of the major war criminals would escape. So that even if you escape to another country, you will be tried in absentia. Then that country can extradite you, and then you now face your charges. But currently, as we know it currently, I would say it is not right. It is a failure, because one of the canons of rule of law is, for example, to ensure that an accused person faces the accuser. for example, you listen to what you are accused of, and then also you are given a chance to respond. So, for example, Mr. Martin Bowman, it wasn't that chance of response, giving his side of the story was not there because he was tried in absentia. So the long and the short of it, I would say at the time it was successful, but currently, as we know, the international law or our municipal laws, it is not right to try somebody in absentia. Yeah, that is my response. Any other person in the group can also have a bite at it.
Zedekiah, do I make my comment?
Yes, please proceed. So
my hand was up.
We allow group 2 to also make their presentation.
Okay, so my observation from the Nuremberg trial is that, you see, there are certain individuals that were not directly involved in the crime. For instance, the Minister for Finance. But you see that the trial brought in major people that is who contributed in a way to this. In this manner, I think there is the idea of, and I think indeed it is, there was an idea of trying to come up with a punishment for a conspiracy. These people were prosecuted based on the conspiracy against peace and the crimes. And we see this principle is later used even in the United States in the RICO Act, the anti-racketeering laws that was used to reconstruct the Italian mobs. So in your research and compilation, is this an area that you took notice of, the aspect of conspiracy?
Is there anyone from the group who wants to respond to that?
I would like to respond to that. This is Thomas Mlanda. I would like to respond to that. Please come again with the question of conspiracy so that I can get the exact point you are asking. I would like to respond.
Okay. I'm saying the perpetrators or the individuals who are being tried in the Nuremberg trials, not all of them participated directly in the crimes. For instance, there was one of the suspects was a minister for finance. He was majorly dealing with I think it was in the banking sector, but he was brought and charges were leveled against him. To this extent, the criminal liability on this person per se regarding the crimes is not prima facie proven. So I think there is an aspect of conspiracy in that the allegations were framed in a manner that it was coming as a conspiracy. And so those who are involved in this conspiracy were being brought to book. And I'm seeing another precedent later after that in United States when the government was going against the Italian mobs. They came up with the RICO Act. It was an anti-racketeering act that was punishing the bosses for the crimes committed by the juniors on the street, the mobs who are killing people on the streets. But then the drug lords, the big crime syndicates were being punished at the top. And that's why I'm trying to ground it on the conspiracy theory. So did you take note of that?
Your question is not very clear. However, let me try to respond. Normally, we say that history is written by the winners. Those who win, or in English, the English people say that he who pays the piper calls the tune. He who pays the piper calls the tune. Therefore, there are so many conspiracy theories that went around that moment when these trials were being done and these tribunals were being formed. For example, one of the main conspiracy theories that remain up to date is that Holocaust is a sham. It never happened. Despite the existence of these death camps, despite the existence of centenarians who are alive today, who are there at that moment, despite the fact of Auschwitz death camp, which was the main death camp then, still there are conspiracies around that this and this didn't happen. After all, once the Nazi party conducted everything and Germany lost, you realize that most of them ran away into hiding. And specifically, they went to Latin America, they went to Argentina, whereby most of them lived under false identities to try and escape. As a result, most of these trials were done in absentia. One of the very important trials that we can look at to see or to measure whether these conspiracy theories, how valid were they, is the trial of Adolf Eichmann. That this happened in Israel, because Adolf Eichmann was captured alive and he was made to stand trial. And this man decided to defend himself fully in a proper trial. As a result, for the very first time among the Nuremberg trials, we had a trial that provided us with the views of both sides for the very first time. And I think there's no other trial except that of Adolf Eichmann that brought to us the reality of the validity of this conspiracy theory. That is as far as whether the atrocities were true and all those things that were being done, including the fact that Hitler killed himself, whether he was killed. There's a lot of conspiracy theories, but as I say, history is written by the winners. On the other side, did this coming together of the Allied powers, the UK, the USA, the France, and the USSR, was it sort of a conspiracy to ensure that they punish the Axis powers, the ones that they were against? Of course, one of our members has said that actually these are the countries that during the post-war period dominated the international law scene. And this is validated by the fact that after 1945, to prevent any other war, we created the United Nations, and the strongest organ of the United Nations, the Security Council, actually composes of all these four countries that were inside the Allied powers and China: UK, France, USA, and UK, France, USA, and today Russia. You add that to China, who was not part of the Allied powers by then. As a result, it can be said, the argument may be valid, that for them to come together, given that they were winners, they had some sort of conspiracy, it was some sort of a conspiracy to also try to dominate the post-war period, as we have seen. And a good example we see at the Security Council, all of them are permanent members, all of them have veto powers. So it can't be said so. But at the end of the day, he who pays the piper calls the tune. Thank you.
Thank you, Thomas. And I think at this juncture, allow me to invite Group 2. Mwalimu, thank you for this opportunity, and we sincerely apologize for overshooting our time. Thank you. Group 2, the floor is yours.
Mwalimu, perhaps if I may just add something more, with your leave, of course. Or perhaps Group 2 would give me the leave.
Koech, you're a bit faint.
I'm saying that
yes.
Perhaps with your leave, I may comment on the last question that Mwalimu asked on whether it is proper to try individuals in absentia.
Okay, though I see Mwalimu is saying Group 2 should start presentation. I don't know whether you can make your submissions in a minute, so that yes. As Group 2 prepares to put up their slides.
Yes, I think I believe that such trials are improper in the current day and age. However, some of the individuals who are tried in absentia were tied to this particular crime of genocide based on the documents that they signed. So, for example, there were camp generals who signed the rolls of the names of people who were to be taken or were held in their camps. And as such, given the evidence that was produced and adduced in the military tribunal, they were held liable for those crimes. I think it would be very important to note that. Thank you.
Thank you, Coach. Group 2. The floor is yours. Yes, you are. I can hear you. Proceed.
Please proceed to the next slide. So the group members are there. And there is myself, there's Nelson, there's Kiambati, Quinta, Hope Audrey, James Oliech, Bosco, Joe Joroge, and Silvano Mridi. The order of presentation is the introduction will be done by myself, Caroli. Then the powers of the tribunal will be done by Kiambati. The rationale will be done by Bosco and Silvano. Successes and failures will be done by Quinta Atieno, and contribution will be done by Hope Audrey. So I start with the introduction of this tribunal that Bosco, please, that this international tribunal, military tribunal for the Far East, IMFTFE, also known as the Tokyo Tribunal, was established to prosecute persons for crimes committed during World War II in the Asia Pacific region. Potsdam Declaration, which was on July 26, 1945, outlined the terms for Japan's surrender in World War II. The declaration stated that Japan must surrender unconditionally, and it also indicated that those responsible for war crimes would be brought to justice. That was followed by Cairo Conference between 22nd of November and 26th of November 1943, where it was declared the intention to bring Japan to justice for its aggressive and criminal war acts during World War II. Thereafter was London Conference, held on August 8, 1945, which led to the establishment of an international tribunal to try Japanese war crimes. The framework for the tribunal was developed during this August 8, 1945 conference in London. The charter for the International Military Tribunal for the Far East, IMTFE, defined the crimes over which the tribunal had powers, established the procedures for the trial. The formation of the tribunal was on January 1946. This tribunal for the Far East was formally established on 19th of January 1946, and its first session began on April 29, 1946 itself. Now, I invite Kiambati to take us through the powers of the tribunal.
Thank you. My name is Nyari Kiambati. I'll be taking you through the jurisdiction and power of the tribunal. Okay. Under Article 2 of the Charter,
recording in progress.
It states that the tribunal should consist of not less than 5 or more than 9 members appointed by the Supreme Commander of the aligned power. On the issue of voting, all the decision and judgment of the tribunal, including the convention and the sentencing, shall be by majority vote by those members present. However, in cases where the voting is evenly divided, the vote of the president shall be decisive. Under Article 5, the Charter gives the tribunal the power to try and punish Far East war criminals, either individually or as members of an organization who are charged with the following crimes. They include the crime against peace, crime against humanity, and the conventional war crimes. So it's also important to note that everyone in this, everyone shall bear individual responsibility for the crime they committed, regardless of whether you are in an official position or whether the accused was in an official position or you acted pursuant to the order of your government or your superior. In these cases, however, you can mitigate using the two, being in an official position or having orders from above, as if the tribunal may deem it just to do so. And Article 11. This is the main one. It gives the tribunal the following powers: to summon witnesses to the trial, to require them to attend and testify and to question them, to interrogate each accused and to permit comment on his refusal to answer question, to require the production of documents and other evidentiary material, to require of each witness an oath affirmation of such declaration as is customary in the country of the witness, and to administer oath, to appoint officers for carrying out any task designated by the tribunal, including the power to have evidence taken on commission. Additionally, under Article 12, it gives the tribunal the following powers: to confine the trial strictly to a expeditious hearing of the issue raised by the charges, taking strict measures to prevent any action which could cause any unreasonable delay, and to rule out irrelevant issues and statements of any kind whatsoever, to provide for the maintenance of order at the trial, and to deal summarily with any contumacy imposing appropriate punishment, including exclusion of any accused or his counsel from some or all further proceedings. To determine the mental and physical capacity of any accused to proceed to trial. Also, the tribunal shall not require proof of fact of common knowledge, nor the authenticity of official government document and report of any nation or of the proceeding, recording and finding of military or other agencies of any country of the United Nations. Okay. So under Article 17, as I conclude, the judgment will be announced in an open court and will give the tribunal will give the reason on which the judgment is based, and then the record of the trial will be transmitted directly to the Supreme Commander of the Aligned Powers for his action, and sentence, however, it will be carried out in accordance with the order of the Supreme Court Commander for the Aligned Power, which means that at any time it can reduce or otherwise alter the sentence, apart from, of course, increasing it. That is all.
I will invite Silvano to take us through the rationale of the tribunal.
Thank you, Rory, and thank you for the presenter who has just presented. I am going to discuss the first three, and then my colleague will proceed from there. One, the tribunal was formed primarily to prosecute the authors of the war, World War II, the acts of violence and war that was committed in Japan, within the Republic of Japan. And this included the crime of aggression, crimes against peace, war crimes, including conspiracies that went around and went with these crimes. Again, the second reason that the tribunal was established was to establish a legal framework or legal precedents for prosecuting individuals and others for such crimes. And this tribunal came after the Nuremberg trial. So even if you look at the charter and most of the elements and aspects of the tribunal, they borrowed heavily from the Nuremberg trial. So it was also supposed to look at the charter of the Nuremberg trial, and then also establish some legal precedents over certain issues. And then the third point is that it was supposed to bring accountability to the political and military leaders of the war in Japan. It targeted not only military leaders, but political figures who were responsible for Japan's war crime. And the last point I'd like to make on that is that the approach reflected a commitment to holding leaders at all levels accountable for decisions that they contributed to the crime repression. I now invite Bosco to proceed from here. Bosco, over to you.
Well, good evening. I'll be taking us through success and failures of Tokyo Tribunal. And one of the success was the establishment of legal precedent. Well, the tribunal contributed to the development of international law by establishing a precedent for prosecuting individuals for war crimes, crimes against peace, and crimes against humanity, using the legal framework such as the Charter of the International Military Tribunal for the Far East. This helped in setting the stage for subsequent international criminal tribunals. In fact, one of the international criminal lawyers, Professor Sherif Bashonis, commented on this, and he said that Tokyo was a precedent that legal history can only consider with a view not to repeat it. While his comment might be entirely negative, they might serve solely as a guide to prevent the making of the same mistakes. Number two, we have the punishment of key war criminals. The Tokyo Tribunal successfully prosecuted and convicted key Japanese political and military leaders. And these included figures like former Prime Minister Daikoki Hirota, General Hideki Tojo, as well as the Ambassador Hiroshi Oshima. These emphasized the principle of individual criminal responsibility, which laid the foundation for holding individuals accountable for their actions, irrespective of their official positions. And number three, we have the recognition of aggression as a crime. The tribunal's judgment addressed the concept of aggression as a punishable offense, clarifying that planning and waging a war of aggression constituted a crime under international law. This notion was later on reflected in the Charter of the United Nations. Will you kindly scroll? And I'll move to the failures. Okay, one of the failures was the selective justice. Under selective justice, some critics argued that the tribunal was selective in its choice of defendants, since it mainly focused on Japanese leaders, while potentially overlooking individuals from other allied nations who may have also committed war crimes during the same period. This criticism raised concerns about impartiality. Then, at number two, we have an unfair trial. Under this, you see, during the Tokyo Tribunal, allegations of bias against Judges Webb and Jaranila were raised due to the prior involvement in war crime investigations. And yes, they were involved with the prior involvement in war crime investigations and the Bataan death match, respectively. The tribunal, sitting without the challenged judges, dismissed complaints, citing a lack of authority to overturn appointments by the Supreme Commander for the Allied Powers. This reluctance to address bias concerns signaled a belief that the tribunal lacked inherent power to review its establishment terms, despite its judicial nature. So the judgment writing process also raised issues as well, with criticism directed at the exclusion of dissenting judges from its development. Judge Bernard particularly disparaged the fact that the 11 judges never convened to discuss factual findings. The drafted findings by clerks were accepted with minimal alterations, therefore forming the basis of the present judgment. Still under an unfair trial, the the Tokyo was you'll find that there was a broad multinational trial, like despite the multinational composition that had nominees from the UK, US, China, France, Netherlands, among others, the Tokyo Tribunal faced criticism for lacking neutral or Japanese members on the bench. This absence raised concerns about the trial's impartiality, as the tribunal was predominantly composed of judges from allied nations involved in the conflict. In this case, the critics argued that more balanced representation could have enhanced the perception of fairness in the proceedings. Then I'll move to the third one, which is the political influence. Under political influence, the crimes against peace charges in the Tokyo Tribunal, while possibly less legally robust than war crimes, were politically motivated. This trial, the Tokyo trial, was conducted by Western nations, former colonial powers in the Far East, raised questions of Western imperialism, which was absent at Nuremberg. Yeah, maybe just to add on another challenge, that another criticism was the fact that the Tokyo prosecution also faced other challenges that arose from constrained preparation time. They did not have enough time for preparation, superficial knowledge, and ambitious indictment covering a vast range of offenses over an extended period, and over-reliance on document and affidavit evidence. These factors contributed to a protracted and costly trial. Thank you for your time. I'll invite the next speaker, the next member of the group.
Audrey Hope.
Yes, comrades, I hope you are following the charts. Mwalimu has a problem with his mic, and so he has said he's going to allow three or so questions. So, Mwalimu, with your permission, allow me to moderate this session with your kind permission. So, any question concerning Group 2 work? Sorry, I see one from Washington. Actually, there are two. Number one is asking, were the Tokyo trials fair? And the second one, oh, yes, please. Thank you for that response. Another question from Washington. I'm reading from the charts. What have been the long-term consequences of the Tokyo trials? What have been the long-term consequences of the Tokyo trials? Thank you. Yes, proceed. Thank you, Bosco. Koech, do you have a question?
Yes, I have two questions actually, but I will be brief. The first one, I'm hoping that the group can elaborate more on why the emperor himself, Hirohito, was granted immunity, yet his soldiers, or basically the military of the Japanese empire itself, was acting under his command. The second question is if the object of these particular trials were to ensure or to ensure that the individuals who committed these heinous acts and these war crimes were tried, did they come across this particular unit called Unit 731? And what is their comment on that particular unit and why they were not tried in this particular tribunal?
Okay, group 2, anyone? Okay, thank you.
Thank you for that.
Okay,
Maybe
proceed, Coach.
To clarify on the second question.
Yes, clarity on Unit 731.
Yes, my question is the charter of the tribunal itself states that as one of the terms of surrender, stern justice shall be meted out to war criminals. Unit 731 was one of the most atrocious units ever constituted in the history of military science and escapades. As such, they were conducting human trials and many biological trials. My question to the group is why was this unit omitted from prosecution in this particular tribunal in Tokyo? Thank you. Anyone?
Thank you. And Coach?
Yes.
Since we are all open to learning, if you happen to know the reason why Unit 731 was given that that privilege of not facing the leaders of Unit 731 were not tried, would be very happy to hear it if you happen to know the reason. Thank you.
Okay, thank you. Just to at least add on what this particular group has presented on, I would like to bring the attention of the class to this particular unit. This unit was varied over the extent of its operations, but their main goal or aim when it was constituted was to create and develop biological and chemical agents that will aid the Japanese army in their conquest or in their wars in the future. So this particular unit used to conduct experiments on human beings, and they, as we have come to understand, that the first step to conducting genocide is to dehumanize an individual. So this unit used to refer to these individuals or these persons that were being used as test bodies as logs, human logs. So the first step is to dehumanize them, and then they used to carry out experiments, mostly biological, chemical. So they would inject individuals with these diseases, for example, anthrax. They will freeze you to death to see the effect of frostbite on the body, on the hands, how much blood one individual can lose in an experiment or during surgery before they could actually lose their life. So that is just but a glimpse of what this particular unit used to do. As I had earlier mentioned, one of the articles of this particular tribunal was to ensure that stern justice will be meted out to all war criminals. But this particular unit was lucky enough, or as many would say, or has earlier been alluded to, that the winner of the war will always write the history. So this particular unit was, majority of the scientists in this unit were captured by the US, and they were granted immunity in exchange for the data that they had collected over the course of the war. It is important to note that this is a violation and of international law, but he who pays the piper calls the tune. And since the US was among the Allied forces that won the Second World War, they could instigate and move the cards as they deemed fit. So I would urge the class to read more into Unit 731. But as I finish, some of the members of Unit 731 were tried and were jailed for sentences ranging from 2 years to 25 years. They were, however, not tried in Tokyo. They were tried by the Soviet forces in a trial, a war crime trial known as Khabarovsk. So justice was somewhat meted, but maybe the class can read more to understand more on this particular unit.
Thank you, Koech. I see on the chat, let me see, Hope Audrey, I think one of the members. No, let me start with Alfred. Alfred says that Thomas Mulanda, my question was on common plan and conspiracy as a crime, which we now see reoccurring in Tokyo Tribunal. Okay, thank you, Alfred. Hope Audrey, a member of the group, says that both the Nuremberg and Tokyo Tribunal recognize superior responsibility in that military and civilian leaders were held accountable for crimes committed by their subordinate if they knew or should have known about unlawful actions and failed to prevent them. Yes, that is also known as respondeat superior. Washington says political expediency. The United States, the primary forces behind the Tokyo trial, was more interested in gaining access to Unit 731's research data on biological and chemical warfare than prosecuting its members for war crimes. The US government believed that this data could be valuable in its own research on these weapons. MacArthur, I think that was the Supreme Commander, granted those involved immunity in exchange for information they had gathered while doing their experiments. I think they are responding to why Unit 731 was given immunity and their leaders were not prosecuted. Washington goes ahead to say, Cold War considerations. The United States was also concerned about the potential release of the Unit 731 data to the Soviet Union, a rival superpower. By granting immunity to Unit 731 members, the United States hoped to prevent Soviets from gaining access to this sensitive information. Lack of definitive evidence. The US also argued that there was insufficient evidence to convict Unit 731 members of war crimes, as much of the evidence was classified or difficult to obtain. This lack of evidence made it easier for the US to justify not pursuing prosecution. Okay, thank you for that, Washington, and those who have contributed. Yes, Mwalimu is saying good job to the group. Yes, good job to the group. And as challenged by our brother Koech, Kangogo Paul, we need to research more on this Unit 731 so that we understand, we might not understand fully why the US, granted their leaders immunity, but we need to understand, we need to research on that unit and, read further on it. I don't know whether there's any other issue to be tackled, Mwalimu. We are open to your suggestion. Yes, Mwalimu says in the absence of any other question, we can declare the class closed. Unless someone has a burning issue, then the class stands closed. Finito. Okay, good night, everyone.
Good night, one.